Okay, guys, welcome to another Ultimate Edge webinar series. This is a good one. I'm going to talk about something new and exciting, and I just learned about it recently myself, and it's the new landlord-tenant laws that were passed fairly recently in the city of Tacoma. I have two guests with me here. Jason Anderson is an attorney. I've known Jason for a while, and he's helped me out on a couple transactions, and they're, of course, kind of interesting stuff. That's what we work on here. So thanks, Jason, for joining us today. We have Brian Bouchard. Brian and I have known each other for probably 20 plus years, and Brian is a real estate investor in Tacoma. He's got a bunch of doors, and actually, guys, I'd like you to kind of add to that introduction by just giving a little more background on yourself. So Jason, a little background on you, please, for the audience.
Okay, I'm Jason Anderson. In May, I will have been practicing for 20 years here in the state of Washington. I've done a variety of work over that 20-year period. My first job was with the King County Housing Justice Project. So on the other side of what many of the landlords are facing right now, although that's been nearly 20 years ago. I do mostly real estate litigation, and I also deal with real estate partnerships, acquisitions, and those kind of transactions. And as a sideline, do landlord-tenant law.
All right. And Brian's long background, so I'm looking for here, Brian, in the real estate industry. Go ahead, give us a little more, please.
I have been in the real estate business since 1989, I guess, as in many capacities. However, mostly what I do these days is property management. And I am feeling this, the effects of this TMC directly now as of February of this year.
Brian, how many properties do you manage only your properties, or do you manage other properties, first of all?
Well, I've managed other properties through the years. I don't do that much anymore. Mine keep me busy. And that's 30 plus stores now.
Okay. All in Tacoma, is that correct?
No, spread out, but a good chunk in Tacoma.
All right. So Brian's got a lot of experience in Tacoma. There you go.
Yeah,
Jason, for the audience here, I'm sorry, Brian, go ahead.
Oh, I was just going to say, including some international rentals now too, but they don't have these. They don't have these crazy TMCs. So
I remember. Yeah, I forgot. You're in Mexico, right?
I am now.
All right, that's exciting too. For the audience, both on YouTube and on our webinar audience here, guys, if you're in the webinar audience and you have a question, please put it in the chat box, and Brittany and I will monitor that, and we'll ask questions as we go along here. And Jason, to start things off, can you just give us what the basic eviction process would consist of without trouble? If landlord came to you and said, I need to get this person out here, what are the steps?
Okay, well, could we share my screen? There we go.
There you go.
Okay, so imagine that there's a bunch of footnotes, but here's kind of the basic eviction process here in Washington if everything goes well. You start with, in a traditional non-payment of rent, you start with either a 14-day notice or a 30-day notice. If you have a federally subsidized mortgage, in some cases, it's safer to issue a 30-day notice due to some overhang from the Washington CARES Act. But for most of you, you can issue a 14-day notice to pay or vacate. Now, the first problem that people run into is they simply post it and walk away. You actually need to attempt to knock and hand deliver it personally before you post it. And I've seen commissioners dismiss cases before where the landlord didn't knock before they posted the 14-day notice. So you post the 14-day notice, or you hand deliver it if they open the door. Then you have a 14-day waiting period. I recommend that my clients not accept partial payments. And after the 14 days go by, the next step is the service of a summons and complaint. Summons and complaint, you would retain an attorney for that process typically they'd have a process server do it. You must attempt to serve that summons and complaint in person. If they're unable to serve it in person 3 times over the course of at least 2 days, then you can serve by posted and mail. The return date on the summons and complaint, it needs to be more than 8 days. What I typically do is I do a 15-day return date, because I never know if there's going to be problems with service, problems with getting somebody there. We need that cushion. If there's no answer, you can then file your motion for default. And after the motion for default, you get your court order. You take your court order, you take it downstairs to the sheriff, who will post it and give the tenant 4 days to move out. So in paper, you can get your eviction completed in roughly 33 days. In practice, it is typically much longer than that, and we can go into some of those delays. But in theory, if the courts are not crowded and the sheriff is not busy, the fastest you can get it done is 33 days.
Jason, does that process vary between municipalities much? Is Seattle similar to that? Is time frame about right, or countywide, or how would you comment on that?
So yeah, so this basic timeline is going to be the same from place to place as far as the timeline for these particular events. Tacoma's issued some additional restrictions that go on the date that the sheriff can actually conduct the eviction. And there are numerous differences from county to county as to how busy the sheriff's office is.
Okay. All right. Brian, boots on the ground, been doing this for a while. Comment on that process, and what kind of success have you found, and where are the problems that you found?
Okay, I have a question for Jason here with regard to number 2 that I think a lot of landlords would appreciate. You do not have to accept partial payments. Let me give you a real case example here. We have a guy who he pays a portion of his rent, a majority of his rent, but he gets about 33% of it from a subsidized housing outfit. Those subsidized housing checks come to us, and we have cashed those checks, being 30% of the rent, and apply it to the oldest amount of rent due. You see a problem with that, Jason?
So not as described. There's two things that I would watch out for. The first thing that I would watch out for is many times when you're getting a voucher, right, from one of these aid organizations, it will be accompanied by a letter that says that you've agreed that you've paid the rent full. So you need to look at that and make sure that you're not agreeing to something by cashing the check that you don't know you're agreeing to. And then the second is you need to make sure that the receipt that goes to the tenant is clear about how it's applied. Because if you apply your rent to the last month's rent and not the rent from 6 months ago, there are commissioners here in King County that will say that you are no longer allowed to use the unlawful detainer process 4 months prior to the last month where you applied the rent. So if you take the money, make sure that you read any letter attached to it, and make sure that it's clear to the tenant in the form of a receipt as to how it's being applied.
Okay, so in that case, then this portion of the rent should be applied to the previous month only, not to the oldest outstanding rent until paid.
No, it's backwards. You want to make sure that the rent is very clearly applied to the oldest rent. Right. So let's say they didn't pay 6 months ago and they're starting to catch up, and for some reason you trust them. When you receive the payment, you would apply it to, your October rent, and the receipt would say applied to the October rent. Because if you have given them a receipt that says we applied this to the March rent, then you've not waived your contractual right to the rent owed before then, but you've waived your right to the default and the termination of the tenancy based on the prior rent.
I see. Okay. Okay, John, could you repeat your question again?
Yes, from your experience, I know you've been through this more than once. Where do the problems lie there for the landlord? And how do you successfully make this process happen? And you can broaden your answer, Brian. Is it, I don't know if the right word term is, give them an incentive, a reward for leaving early? Do you find that helps? Or is that the right thing to do or wrong thing to do in this particular situation? And, you know, what's worked and what hasn't?
Well, cash for keys has worked in the past. In fact, just did that with a tenant. It's hard to answer that question in today's environment since December 8th, 2023, because so many things have changed. The old way was a quicker process than even this that Jason's outlined. And we typically did not do cash for keys. But now there are so many requirements that it makes it difficult to, let's see, how can I say this? It makes it difficult to know how to proceed. You have to be very careful up front how you accept and proceed with the tenant so that you cross all your T's and dot all your I's when the day, if the day ever comes that you have to evict them. I think that maybe the best way to answer that question is not to talk about it in terms of yesterday, but how the TMC here in Tacoma affects landlords now, and then move through that. And I do have one real life experience with that already.
All right. Well, let's describe the law change. What does the acronym stand for that you've been using, Brian?
TMC 1.100 is the 0.000 is the new Landlord Fairness Initiative. I love the way that they've named this thing, right? Landlord Fairness Initiative. And prior to that, in July of last year, they passed 1.95. That was some new changes to the Landlord-Tenant Act citywide. And then this Landlord Fairness Initiative was piggybacked on top of that. In particular, I mean, there are several changes in 1.100, but the ones that are going to cause landlords the greatest headache is 1.100.060. In there are two eviction moratoriums, the cold weather eviction moratorium and the child enrolled in Tacoma Public Schools moratorium. Would you like me to explain those quickly?
Yeah, you explain, and then Jason will have you comment on them, please.
All right. So the first one is the cold weather eviction moratorium, which says that for any reason that a tenant can stop paying rent, and you cannot evict them. We just had a real life experience with that, with the tenant who was served in February, about a month and a half prior to the expiration of this year's cold weather eviction moratorium. And the judge sent us, or the clerk sent us back a note saying that they would not hear the case because of this moratorium. Now that affects everyone. Now the other one only affects families that have a child enrolled in the Tacoma Public Schools that is 18 years or younger, I believe it is. It could be 17 years or younger. Jason would know more about that. It's either 18 or 17 years or younger who is enrolled in the public schools. In that particular case, you cannot evict for non-payment of rent for any reason for the entire school year.
Jason.
Yes.
Comments, clarification. What do you think? Brian, nail it there?
Yeah, no, that's a fair summary. You can start the process, the eviction process, during these barred times, but actually physically carrying out the eviction, having the sheriff go there, that cannot occur during these windows of time.
Yikes. So guys, put some questions in the comments because I got lots of questions myself. But if you have any, I'll look at those in just a minute here. So during those times, for those reasons, either winter or if you have children, the school year, you can't get anybody out. So does it make any sense to even start the eviction process there to get some ground underneath you so that when the term of that period, winter or the school year ends, that you're further ahead? Or what are the options you have as a landlord?
Yeah, so you want to go ahead and get the eviction started during the barred time period, because at least you can get through that 30-day waiting period. The first set of process, right, it takes approximately 30 days. You can at least get those 30 days done before the bar is over, right? So if you're looking for March 31st, you want to evict on April 1st, you can go ahead and file the action, at the beginning of March, get the judgment, but then you'll have to wait on the judgment until the cold winter moratorium ends, and you send that into the sheriff.
All right.
And you're also, the other consideration is that for school-age children, court can go in strange ways. And so if you've only got about 90 days during the summer to finish an eviction and to get them out before the new school year starts, you want to get it started as soon as possible in case they have some really clever defenses they come up with that take an extra few months to get through.
I have a question for Jason. If you have the process started and you now move into the next school year, would the court, in your opinion, continue the case because it was started during outside of the moratorium?
Well, what I think the best interpretation of the statute is, what the ordinance is that it does not prevent you from pursuing the case and obtaining the judgment. And what it does is it prevents you from sending the sheriff out to execute on the judgment after you get it. But let's say you have somebody that you start evicting in the middle of July, and for a variety of reasons it gets continued out and you don't get your judgment until the end of August. If the sheriff is unable or too busy to get out there before September 4th, then the sheriff is not going to execute until you get to the end of June of next year.
Wow.
So you could get a judgment, but you couldn't get them out if their school had started and they were in the house still.
Right.
Wow. Yeah, that amazes me. John, I'd like to say something that's related to this, if I could.
Sure.
What effectively this is going to do is the exact opposite of what these people who presented this, the original Prop 1 had intended. It's going to, I guess, force or inspire landlords to avoid renting to families in any way they possibly can, by perhaps increasing the qualifications so high in the beginning that they couldn't possibly meet it anyway. So and they wouldn't then rent to them. So in the end, who pays for that is the family.
Guys, I want to move to the long-term ramifications, which we're kind of leading to, Brian. Before we go all the way there, because I'm going to ask you this question again in just a minute. What can landlords do now that's fair to good tenants, that protects the landlord from finding themselves with bad tenants, which are going to take advantage of this new set of laws? Comments from each of you on that.
I talked with Jason last week about this, and doing your due diligence and screening well up front is really the key to this. And it was always like that but now you really have to be careful, super careful. And unfortunately, in our case, we used to make exceptions for people who were what we would call high-risk tenants, but we can't do that anymore. So the end result is that the inventory that would have been otherwise available to them before is no longer available.
Jason.
Yeah, that's the first issue is basically your ability to resolve a bad egg is much lower than it used to be. So the best way you can protect yourself is having fairly high tenant requirements, and sticking to them, which is unfortunate from a public policy perspective, but for an investor perspective, that's what the result is, because it's very, very hard to protect yourself after they're in there. You've got to get the paperwork done right. There's a bunch of new laws that you're going to have to keep track of, so that you're in compliance while you're servicing these tenants once they're in. And you're just going to have to be really quick to start the eviction process for the tenants to go bad.
So guys, go ahead, Brian, sorry.
Well, I'd like to add something onto that to say, to show you what we're doing, excuse me. We're finding that in order to attract the good tenants, we're doing two things. We're making sure that our units are as high a quality as possible, dressing them up a little bit within a budget boundaries that we have. But the other thing is that we have to, I guess, just going back to partly what we said before about screening up front. When we do the screening, it is really important at that point, plus in our marketing, to give the appearance or the appearance of a good deal. So we typically we go to HUD and we do Zillow average market rent rates in the area. We do our rent surveys. And we find out what rent is on the average for certain types of units that we rent. And then we discount it from there. We're in a position to be able to do that, but new landlords who might have purchased a duplex, triplex, or fourplex may not have that cushion to be able to offer discounts like we can. As you know, John, we've been in this for a little while, and so our mortgages are paid down a bit, but on the other hand, taxes in this particular area of Tacoma have skyrocketed, and I don't know if everyone realizes, they probably do if they're a landlord, that property insurance has doubled in the last 120 days. Our insurance policy doubled. So it's tough to be able to find that, to be able to whittle away a little bit at that profit margin, but you do attract a better prospect when you do that, and you get a bigger pool. So it helps us to keep our units up to snuff and maybe a little bit more, and then offer either some initial rent discounts, or perhaps a discount over the entire lease period, or some other type of benefit. In some of our buildings, we give free laundry. And I had one of my tenants say, well, you know what, Brian, I love this place. It's great, because I always ask them, to add value to this rent increase that we're going to do, what would you like to see in your apartment? And most of them have said, well, nothing really, everything's great. But one guy said, I'd like to see my free laundry room time doubled. And that was an easy yes. This particular tenant had been there for over 5 years, so and paid all the time. So it was a no-brainer for us to do that, and it's inexpensive to do something like that.
There's a lot of wisdom there, Brian. Give them an incentive that they like, that it doesn't cost a lot for you, the landlord, and get good people to stay. That's a very good thought. Guys, I got to ask you both. You're going to try to screen this a little better so you don't get those people. And I mean, some landlords might say, I'm not going to take any families with children, period, right? I don't have to worry about this. Doesn't this get kind of discriminatory here? And how are you going to avoid that and be careful of the law there?
Well, it's kind of like what Jason had mentioned before. You have to increase your qualifications up front. I don't know how many people in my area have a credit score of 775. You know, there are some, and there are probably plenty that do have that have great jobs, that could afford a more expensive apartment, but they're looking for a deal because perhaps they're saving for a down payment to buy a house.
Jason, what are your comments on that discriminatory issue?
Yeah, so it's an issue. I know that some cities, for example, in Seattle and some other spots, have first in line ordinances.
Right.
Which means that if a tenant who qualifies applies, you have to take them, even if you have a bad feeling about them. And so what that effectively means is that you need to have it very clear up front. This is the credit score we require. This is the proof of income that we require, and get that high enough that the odds are pretty good that that tenant is going to be good for you.
I would like to add to that by saying that the TMC here, the Landlord Fairness Code Initiative, puts limits on how much income required is egregious. In other words, I think 3 times rent is the most that they will allow, but in some cases in that TMC, it's a 2.5. So on one hand, the TMC cuts off your ability to get people who would make more that would be better tenants, but on the other hand, you are trying to get better tenants who can pay so that you can give them these deals. I mean, I got to tell you, it's just it's amazing this thing.
Yeah.
It exists.
Do I understand this properly then from what Brian said, Jason and Brian both? You can screen on credit score and you can screen on income. Is that what you were saying, Brian?
Yes, that's correct. And I think that the easier way to do it, because of the limits on income, is the credit score. That is kind of the gray area, if you will, or you have a little bit more latitude with that. But as you know, John, what credit score are we using, right? Because there are three for personal lines of unsecured credit, but you, Mr. Murphy, require a different type of credit score from a different algorithm when it comes to gaining loans.
Yeah, so I suspect, tell me this too, Jason, maybe from a legal perspective, there's 2 questions I have. One is the credit score. You have to use perhaps the same model for every tenant that applies. Otherwise, if you use different models, would that be considered discriminatory?
Yeah. You need one set standard for whoever's applying for it. Okay. So one set credit score that you're working from. Okay. I mean, you could say it's an average of TransUnion, Equifax, and Experian, for example. I mean, you can be creative in how you set the standards, but then you have to set them for everybody that's applying.
You gotta be consistent. Okay, so what other things before we leave this topic can you, as a landlord, screen by that are legal and fair and non-discriminatory to help you choose a really good tenant? Any other things, guys?
What we now require is, and I literally just updated the screen form. I believe that it's 4 years of employment with the same employer and at least 2 years of completed lease residential history. It doesn't have to be with the same landlord, but it has to be 2 years of completed leases.
Okay, Jason, any other ideas that you have?
Well, I mean, the other is is you may have to get together with your lawyer and go through your policies and procedures and make sure that you're dotting your I's and crossing your T's with how you manage these units. Because with Washington guaranteeing every tenant an attorney in an eviction action, they're getting really good at finding landlords that are breaking the law. Most people probably have a pretty good handle on what the Washington Landlord-Tenant Act requires. But you also have to deal with your local jurisdictions, which will surprise you. We've just talked about Tacoma, which is the most strict at this point. But for example, I've got a case I'm dealing with right now in Redmond that had some extra wrinkles that kind of surprised the landlord. So your operating cost is going to go up a little bit, and you got to really take a look at your procedures and make sure that they're not uniform across the state, that you might have to do a different one for every jurisdiction that you're in.
Oh, wow. No kidding.
And it's important to acknowledge that this, to me at least, this is my opinion, is that this is not the complications that have been instigated here in this new TMC, specifically the 1.00, have made it so complicated. I believe that was done purposely so that attorneys could punch holes and find those errors where landlords, had good intentions, but they weren't aware, or whatever it might be, and the attorney finds that, and then now the case is compromised.
Right. We have a lot more questions I wanted to ask. We're going to have to extend this. I'm going to invite you guys, if you might come back with us again. Can we get both on again?
Absolutely.
All right. And I do want to ask one more question. So Kim asked questions first, then I have one more. I want to help wrap this up. Kim says, if you advertise that you require a certain credit score, can you make an exception?
We don't know yet. That issue has not been litigated. I think there's a good argument that you could, but you are facing a small litigation risk that the courts may go the other direction. That's not been adjudicated yet. No court has decided on that issue. I believe the law should allow for that, but we don't know that yet.
I think that also you would have to have a good reason for making that exception. I think it's going to come down to that. Would you agree with that, Jason?
No. It's either going to be you can make an exception when you want to, or you can't. Yeah.
So the court's not going to say why you made the exception, and you have a valid reason, doesn't make any difference?
So if you go into you just go into a whole lot of really fuzzy areas, right? The big bugaboo is are you being secretly racist, right? That's one of the big issues. Are you being secretly sexist, right? Those are various issues. And the courts are not going to want to deal with that. It's either going to be you have the right to contract. That's kind of a fundamental constitutional principle, and while there are restrictions on it, if you've got 10 people that come through and none of them qualify, it seems like you should be able to go back and pick one of those people. Just understand that it will be interesting to see how the case law develops, but I think it's going to be an all or nothing as far as how the court's decided.
So you could be helping set precedent here and shaping future cases, huh?
Yeah.
Pioneer.
It's great for lawyers and bad for the people trying to set it.
All right, so that leads you to our last question. We may not get this one done because we're probably over now, but I really want to ask both of you. What do you think the long-term ramifications of this new law in Tacoma is going to be, both to landlords and to tenants? Brian, you kind of started on that, so why don't you go ahead and pursue that question just a little bit?
Well, if just 10% of tenants out there decide from the cold weather eviction moratorium just simply to stop paying rent, that's going to have a huge, huge impact on the industry, especially for the mom and pops that is 50 doors or less. I just read an article in the Seattle Times 2 days ago that said in Western Washington, $177 million of back rent is owed. $17 billion total countrywide is currently owed. I think that that's going to drive a lot of small landlords out of business. Will there be lawsuits for harm done because of this? Probably yes. That's more a Jason question. I think that personally, I think it's unconstitutional. Section 3 of the Washington State Constitution says that citizens will not be denied their personal property without due process. But if you can't get possession back from a tenant who's already shown a propensity to not want to pay for that, and you can't go through the process, a process that our tax dollars pay for, the court system, then they are effectively denying me my due process. I don't see how that can fly. I'm really surprised that there's no cases pending in at least Washington State Supreme Court right now with regard to this. I'm sure that I'm not the only one that's lost money already from the cold weather eviction moratorium. And there's other things too, but we're probably running out of time. So I want to give Jason some time there.
Okay. I'm gonna leave the question as to the constitutionality of that ordinance for another day. Just be aware that unfortunately, coming out of the COVID pandemic, we've had some bad law made the other direction because hard cases make bad law. So we will see how that spins out. I think the two impacts that I'm going to see is that it's going to be hard for landlords in the Tacoma area to serve lower end tenants. You're going to have to either do it in such a volume that you can deal with, you know, a few bad eggs, or not deal with it at all. And I think that the people that do landlording in Tacoma need to be more engaged with the political process. It may be that the temptation come November is it going to be Biden or Trump? But the likelihood that your vote there is going to matter is nearly zero. What's going to matter a whole lot more is going to be what's at the bottom half of that ballot.
And I might add to what Jason said, that this TMC, or the Prop 1 as it started out as, failed by 370 votes out of, I believe it was around 15,000. So yeah, it was a tiny,
almost a tie. Yeah, that points it out. Gentlemen, I have lots more questions, so I'm going to ask if we can get together 1 week from today, same time, same channel, and we'll pursue a couple things. One is maybe a little bit more thought on the long-term ramifications here to both landlords and tenants. Secondly, if this is going to bleed over to other municipalities and what your predictions are, what your thoughts are on that. And then we're getting a lot of questions about people moving into homes, squatters, being able to stay in that home for the rest of their life, and then the owner running away, hands in the air, going, oh my goodness, I can never get them out. And I want to pursue that because we have a lot of questions on that. You guys up for that in a week?
Absolutely. I think, John, that the squatter issue is like probably 2 webinars. That's going to be a big one.
We'll see how that goes. I do want to give Kim one more shot here. She said, back to the credit score, can you make an exception question? In this case, the renter showed the Zillow's credit report was reporting a bankruptcy, but provided a credit report that showed they didn't have one. Jason, how's that fit? You think that's okay for the exception?
Well, I mean, okay, so it depends on how you set your requirement, right? So if your requirement was I need a 700 credit score, then the question is, does a credit report show a 700 credit score? If the requirement is I need a credit report with no derogatories on it, and they had one that showed a bankruptcy, and then they brought in another one that said no bankruptcy. Yeah, you could choose to accept the new one if you wanted to because it met your criteria.
Okay, Jason, can you hear me? You just cut off the very last bit there. You still there?
Yeah, I'm still here.
Okay.
So you would just say, okay, well, for the first credit score must have been a mistake. The new one they brought in meets our criteria, so we'll go ahead and accept that. I think the other question you're asking is implying is, if there was a bankruptcy, could you make an exception? And I believe that you can, but you're in danger of having to set precedent.
There you go. All right. Jason Anderson, Brian Bouchard, thanks guys for joining me today. Appreciate it. I appreciate you also stepping up so we can do this in a week. It's a big topic with lots of questions and maybe not as many answers, but we'll find out. Thanks for joining us, guys. Thanks, audience, for being here. Thanks for the YouTube guys as well. We appreciate it. Thanks, Brian. Thanks, Jason. We'll catch you in a week.
Sounds
Thank
good.
you.